Starting off with the introduction. It is important to note that a good essay answer doesn't go straight into addressing or answering the question, as we must first develop our essays properly so that the essay as a whole will bear some sense of coherence. Because the chapter in question concerns the first unit of the AAS law syllabus, i.e. sources of law, we should therefore briefly define and explain the sources of laws. This is where we will be briefly introducing what the law is and the two main sources of laws, which are written and unwritten laws. Since the question concerns statutory interpretation, we should then direct the introduction to parliamentary laws, which are also considered as written laws that judges have to interpret. From here, we can connect our discussion to statutory interpretation. That it is simply a practice whereby English judges seek to understand particular statute laws so that they can apply them into cases which they are dealing with in court. Now that we are done with the brief introduction to our essay, we should then endeavor to state our objective for the essay. The objective comes in the form of a thesis statement which must address the question, or at least the focus of the question. It is good to have a thesis statement, as this will give the examiner a clear insight of where we are going with our essay, and also to keep us from digressing in our discussion and to ensure that we remain close to what the question is asking us to focus on. With this in mind, we will briefly explain that before we can delve into the topic of intrinsic and extrinsic aids of statutory interpretation, we will briefly discuss the purposive approach that encourages the use of these aids. We will then discuss these aids in detail before giving critical evaluation as to its usefulness to judges while interpreting statutes. Point 1 of the essay should always be treated as a bridging point between the introduction and the core of the essay, which actually critically addresses the question. This is the part where we can briefly stress the importance of statutory interpretation, as well as the two general approaches that are available to judges who are dealing with a case before them. However, the mention of the approach should only be a passing note, and not too much time and effort is spent here. What we could probably do is to stress more on the purposive approach to statutory interpretation, and more importantly to link that brief discussion into the idea of intrinsic and extrinsic aids to statutory interpretation. Some of the more important points that should be highlighted is the actual purpose of the purposive approach and the arguments for and against its use by judges, i.e. the argument between Lord Denning and Lord Simmons in the case of Magor and St. Mellons vs. Newport Corporation, 1950. In point 2, we will be delving into the discussion of the two aids to the purposive approach of statutory interpretation. Here, we can reconfirm some of the discussion made about the two aids to statutory interpretation, or we can go straight into discussing the two aids to interpretation in detail. Firstly, define intrinsic aids and explain in detail the meaning and purpose behind it, as well as how it actually aids judges when it comes to statutory interpretation. After that, some important examples and their use should be highlighted. For example, the preamble, marginal notes, dictionaries within the statute, etc. Of course, some of these highlighted intrinsic aids should be well explained in the essay, and more importantly, it should be explained in a way where it relates back to the focus of the question, i.e. their usefulness. Secondly, after going through the intrinsic aids in detail, we should proceed to discuss the extrinsic aids to statutory interpretation. Again, we should start by defining extrinsic aids and explain in detail the meaning and purpose behind it, as well as how it actually aids judges when it comes to statutory interpretation. Similarly to intrinsic aids, some of the more important or controversial aids should be highlighted, namely the use of Hansard, since it is something that was mentioned in the examination question itself, even though we have established that it has no relation to the question itself. The use of Hansard is a controversial aspect of the intrinsic aids to statutory interpretation. In fact, it is one of the reasons why some people might be against the whole concept of the purposive approach, as Hansard is something that can challenge the sovereignty of Parliament and its lawmaking prerogative. This discussion can be delved into now, or it can be left for the evaluation point in point 3. However, it would be good if we do not just discuss about Hansard, but also have more or less equal discussion on the other extrinsic aids such as international conventions, directives, law commission reports, etc. Point 3 is where the evaluative part of the essay should be. It is crucial that in any essays that ask us to draw comparisons, discuss the advantages, disadvantages, assess usefulness, etc., we must make sure that we leave enough space in our answer to critically discuss the evaluative aspect of the essay. If we were to leave out this part, or that we only leave it as a passing note, then we will lose out a lot of marks that can afford our essay answer a high band mark. Therefore, in this part of the essay, we should revisit some of the key points that we have discussed in point 2 regarding intrinsic and extrinsic aids to statutory interpretation, as well as its usefulness. If we didn't mention much about its usefulness or uselessness in point 2, then this is where we should critically evaluate the usefulness or uselessness of both intrinsic and extrinsic aids individually, while highlighting some of the important points to justify our own reasonings. For intrinsic aids, some of the more critical aspect that could be highlighted is the fact that whatever help it can afford to the judges are limited to whatever that is intrinsically within the statute itself, and so the extent of its help may not be quite helpful. For extrinsic aids, the fact that it may simply challenge the sovereignty of Parliament may be bad enough, but other aspects of its usefulness or uselessness can be highlighted when we mention some of the shortcomings of using the Hansard, such as the fact that it is an unreliable source. However, the case of Pepper v. Hart 1993 has given some limited use to the Hansard as well as some guidelines on its usage which should be mentioned. As always, a simple conclusion will do. We should definitely not insert any more new points into our conclusion, otherwise it wouldn't be a conclusion. Just briefly summarize what has been discussed in the content of the essay and highlight some of the more important points in the essay that may address the question. A conclusion for this particular question should highlight some of the key aspects of the discussion, such as the usefulness or uselessness of the intrinsic and extrinsic aids, together with the writer's final word on the discussion above.